Welcome back. Now, President Cyril Ramaphosa signed the Electoral Amendment Bill into law last week, but it faces legal challenges from several fronts. The organisation Undoing Tax Abuse says the act, which will allow independents to stand for office, falls short on certain issues. Let's bring in Rachel Fischer on that. She's OUTA's Parliamentary Engagement and Research Manager. Thank you so much for your time, Rachel. We do appreciate it. I think I butchered your surname. Sorry about that. But let's just speak about why OUTA is not happy with this.
So let us be clear from the onset that the issues we are raising with this current Electoral Amendment Act are not new issues. From the get-go, once this as a bill was tabled back in January 2022, the same issues occurred. And these were the issues we've been hammering on in all the subsequent public participation rounds, together with other civil society organizations. So fundamentally, the concerns we highlight are around fairness, equality, and accountability. So because what this act must do, as mandated by the Constitutional Court, is to allow for independent candidates to stand for our national and provincial elections. Now, this act that is on the table succeeds in ensuring that independent candidates can do so, but we argue they cannot do so in light of fairness, equality, and accountability.
So part of your statement that you've released, you said the fact that independent candidates can only contest 200 seats in the National Assembly and not the other 200 seats. What exactly is that of concern for you, especially when it comes to them having received more votes? So if an independent candidate receives 250 votes, the other 50 fall short according to this new amended act. Why is that of concern for you?
It's of concern on a number of levels. So look, for National Assembly is split into 200 votes and 200 votes. The first 200 from regional representation as you go and vote within your different provinces. For National Assembly now, not the provincial legislatures. The other 200 votes are what is known as compensatory seats, and they are put together through proportional representation. So these are for political parties that get seats in proportion to the number of votes they received, which makes sense, and this is fair. If now, for argument's sake, you require 45,000 votes to procure one seat in Parliament, what that means, if you're a political party and you've got a couple of candidates standing, you've got multiple, more than 450,000 seats, let's say you have 90,000 votes, you get 2 seats in Parliament. If you are an independent candidate, because you can only effectively stand for one of those 200, if you were to get 45,000 seats, votes, yes, you get your seat. If you get 90,000 votes, you don't get the additional seat. That gets thrown away. So you cannot go and allocate another person or another independent candidate to take that seat on your behalf, which makes it problematic. Essentially, we are saying to citizens, and essentially saying to citizens that wish to see independence standing, that your votes don't matter and we're throwing your votes away. Because essentially in our democracy, we wish to argue that every vote must count. And with this current act, it does not allow for every vote to count.
So obviously you're arguing on the basis of fairness, because if an independent candidate, as you mentioned, gets 90,000 votes, it should be counted in, especially when it comes to getting a seat in National Assembly. I want to ask you around your concerns around the Electoral Reform Consultation Panel, because you are worried about the individuals that might be sitting on that panel that ultimately will be making critical decisions about this act.
Yes. So let us also remind ourselves that there was previously a Ministerial Advisory Committee constituted back in 2021 through the Minister Motsoaledi. And the aim of the Ministerial Advisory Committee was to do research on international best practices, looking also at the South African context and making recommendations as to the most appropriate system for South Africa. 2 options were recommended. Now, popularly, they are known as the majority and the minority options. Minority is because the minority of the group voted for it. Majority option is the majority of the committee voted for it. So in a democracy, you would think the majority vote wins. Not in this case. So that really raised concerns. Why did the minister not select the option that got the most amount of wins that could potentially lead to the most appropriate system? Therefore, with this electoral reform consultation panel, we are effectively seeing what I call a MAC version 2. It's a duplication of an already established committee with the aim of doing international research on best practices, looking at the current context in South Africa, and recommending the most suitable model for us going forward. All of these which must seem really familiar to everybody. The reason then why we are insisting on this panel is to have civil society representatives or a representative of civil society on this panel. Over the last couple of years at least, and even longer, we have formed a collaborative instance of numerous civil society organizations and citizens that are very concerned about this.
Yeah.
We meet regularly, we have regular discussions on this. So we know and we do feel the pressure that we have placed on Parliament has resulted in this panel. We want to continue placing this pressure on Parliament to ensure whatever transpires in this panel comes back to the civil society organizations and we get information coming back to transparency issue that I mentioned in the beginning, and we can take it up and hold them to account if the best and most fair option does not realize.
Okay, and then just lastly, Rachel, will you be heading to court or are you just assessing the situation for now?
We are assessing the situation for now. We need to admit where we are currently standing as South Africans is that we can ignore court action at this point because we do not want to disrupt the apple cart. But should there really be constitutional concerns in this Electoral Amendment Act and the elections occur next year, if any other individual or political party is unhappy with the results and they have enough evidence to base an argument onto the unconstitutionality of the elections, they can take it to court and try to have it declared moot. So the problem is the intense financial, reputational, and constitutional concerns we are facing if these issues are not being addressed. So the question is really going to court now or going to court later. It's really important that we do this with rationality and open minds.
Okay, great. Thank you so much for your insights and giving us clarity on what exactly OUTA feels about this. That was OUTA's Parliamentary Engagement and Research Manager, Rachel Fischer.